Hey, boys and girls, welcome back to Freedom Steel. I'm Todd Vandermeid, former lobbyist, and today, so this one, it could be titled a couple of ways: Range v. Lombardo, or Atkinson Part Three. So after I did the videos on Atkinson on the government's case, come to find out that another case on 922G1, those prohibited persons because of felony or equivalent convictions, was decided in the Third Circuit. So we've got this case in the Third Circuit, and it turns out it was argued by the same guy that argued in the Atkinson case for the government, a guy by the name of Kevin Sutter. And they offered up the same exact arguments. But as you heard in the Atkinson orals with the judges challenging the government's position, this time they got the result they wanted. So we're going to go through here. I'll scroll through some of this, going to try not to get you too much vertical or anything with my scrolling, but it's Third Circuit Court of Appeals, Range v. Attorney General of the United States of America, Regional Lombardo, Acting Director of Bureau of Alcohol, Tobacco, and Firearms, Eastern District of Pennsylvania, argued September 19th, decided November 16th. So you had just about a 60-day lapse. Three-judge panel of the Court of Appeals. So let's get to it. It's a per curiam, so it's a unanimous decision for the court, three-judge panel. In District of Columbia v. Heller, the Supreme Court held the right of the people to keep and bear arms enshrined in the Second Amendment as an individual right. While the precise contours of that individual right are still being defined, the court has repeatedly stated that it did not question the, quote, long-standing prohibition on the possession of firearms by felons, end quote. So 922G1 deals with felons or the equivalents. If you have a misdemeanor charge in which you could be held in jail for more than 2 years, that qualifies the same as a felony. The gentleman here was convicted of a misdemeanor that could have had him in prison in Pennsylvania for up to 5 years. Appellate Bruen Range falls into the category having pled guilty to a felony equivalent charge of welfare fraud under PA statute. He now brings an as-applied challenge to 18 U.S.C. 922G1, contending that his disarmament is inconsistent with the text and history of the Second Amendment and is therefore unconstitutional under New York State Rifle and Pistol Association v. Bruen. We disagree. Based on history and tradition, we conclude that the people constitutionally entitled to bear arms are the law-abiding, responsible citizens of polity, a category that properly excludes those who have demonstrated disregard for the rule of law through the commission of a felony and felony equivalent offenses, whether or not those crimes are violent. Additionally, we conclude that even if Range falls within the people, the government has met its burden to demonstrate that its prohibition is consistent with historical tradition. Accordingly, because Range's felony equivalent conviction places him outside the class of people traditionally entitled to Second Amendment rights. Okay, this is going to be one of those learning lessons, teachable moments for our side of the issue. They talk about long-standing prohibition. They also talk about the people who are law-abiding, who fall within the term the people. This is a dangerous decision. This decision goes off on tangents and sets up something that is very, very scary if followed to its logical end conclusions. And we'll get into that a little bit here. If this video starts to run long, I will cut it up into a couple of pieces like I did Atkinson, but let's see if we can get through this stuff pretty quickly so as not sit here and because the government has shown that at issue prohibition is consistent with historical tradition, we will affirm the district court summary judgment in favor of the government. scroll through all this stuff about why he wants to own a gun for hunting and so on. Applying Bruen, they want to call it Bruen. It's frickin' New York. It's New York. New York State Rifle and Pistol Association. That's the case. Applying Bruen's historical focus, we conclude 922G1 comports with the legislature's long-standing authority and discretion to disarm citizens unwilling to obey the government and its laws, whether or not they have demonstrated a propensity for violence. We proceed in two parts. We begin by explaining how the Supreme Court replaced our two-step framework with a distinct test focused on the text and history of the Second Amendment. Next, we examine disarmament laws from the 17th to the 19th centuries. Okay, let's hold up there. You don't get to look at 19th century law. The framework around the Second Amendment is 1791. And when you say 17th century, I bet you're going to try to bootstrap up a bunch of pre-colonial law and import stuff that has very little basis on this. So, as we get through here, only if a firearm regulation is consistent with the nation's historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. True, you got that right. Additionally, because the Constitution presumptively protects individual conduct covered by the Second Amendment's plain text, the court explained the government has the burden of justifying its regulation of that conduct by demonstrating not simply that the regulation promotes an important interest, but rather the regulation is consistent with the nation's historical tradition of firearms regulation. Yeah, you're getting the test right, that the burden shifts to the government. It never should have been on us. It always should have been on the government. But here we go. Bruen does not preclude our review of Range's appeal. On the record before us, Bruen did not address the substantive issues that we must now determine, unlike the open carry licensing regime of Bruen that created a conduct-based constraint on public carry. 922G1 imposes a status-based restriction, namely a possession on the ban of those convicted of crimes punishable by more than 1 year in prison or by more than 2 years in prison in case of state misdemeanors. Yes, except New York was not an open carry case. New York was a may issue case. It was sitting there dealing with the must have a good reason. You guys didn't get that right. I bet you're not going to get a lot more right in here. You don't even understand what Bruen was about. In Binderup, we had imposed a burden at step one on the challenger rather than the government. But after Bruen, we note the government must now meet its burden in the district court. Yes, absolutely. The burden is on the state, not us. Because Bruen came down after the government made its case in the district court, we looked to its filings in the district court, as well as its supplemental briefs on Bruen's impact, to find it has met its burden. Well, this will be interesting to read. These appeals require us to decide who count among the people to keep and bear arms. Yep, they're going to do a deep dive into what the people is. They telegraphed that. So let's pause for a second here. We learned from Heller that when they didn't like the decision, they would try to cherry pick pieces of Heller to hang by the thinnest of slivers, whatever they could. So they said in the beginning, well, it was just about the home, because in the holding of Heller, it sat there and said, for lawful purposes, such as self-defense within the home. They just seized on in the home. They completely overlooked, ignored, and just discarded the such as, which was descriptive, a modifier. Wasn't only self-defense in the home. Those such as and only have two different meanings to it. Then they go to dangerous and unusual. So They want to make it read dangerous or unusual, which is not what Heller said, dangerous and unusual. And then they try to go after long standing. And now in New York, they have identified what the time frame is to be looking at, understanding that in the New York case, the Sullivan Law was turn of the century 19 early 1900s, somewhere between 1911 and 1930, and that wasn't long-standing enough. So anything prior to that should, or post that, should definitely be out of the question. But let's see what they try to bootstrap up here with their stuff. The holders of the Second Amendment rights as law-abiding citizens no fewer than 14 times. So they're going to use that phrase, and they're going to bootstrap up and try to define law-abiding citizens to give them something to stand on. That's what they're going to do here. Ray Charles could see this coming. These include its holding that the New York statute violates the 14th Amendment and it prevents law-abiding citizens with ordinary self-defense needs from exercising their right to keep and bear arms. Its explanation that the Second Amendment elevates above all other interests the right of law-abiding responsible citizens to use arms for self-defense. And its instruction to identify historical analogs to modern firearm regulations by assessing how and why regulations burden a law-abiding citizen's right to armed self-defense. Okay. In the Seventh Circuit, they took on this, and this government lawyer tried to make this case. And let's play the audio from that as a refresher. So roll tape.
And Your Honor, I think that's why it's important to take the Supreme Court at their word on the types of prohibitions that are permissible under their Second Amendment jurisprudence. And I think in particular footnote 9 of Bruen helps illustrate that in explaining why a shall issue licensing regime is appropriate, the court said the reason it's appropriate is that it helps ensure that arms are only in fact available to the law-abiding citizenry, and that only the law-abiding citizenry can overcome.
I don't think you can sign us up for just a broad endorsement of the presumptive validity language in Heller and McDonald after Bruen. I mean, good luck, but I'm not signing on to that.
So, the Seventh Circuit seems to have a very, very difference of opinion than what the Third Circuit is starting to outline here. Also quoted 19th century sources extending the right to keep and bear arms to all loyal and well-disposed inhabitants and disarming any person who made an improper or dangerous use of weapons. That's interesting. We know for a fact that the anti-gunners have been trying for years to turn around and expand the number of disqualifying charges. They keep trying to expand DV stuff. They keep trying to expand misdemeanor stuff. So, somebody grabs your wife's ass in the bar, you turn around and you cold cock the guy for it, and you get charged with a battery. They want to make that a, prohibiting offense because now you've shown a propensity for violence, irregardless of the circumstances. So we know where they're going here. Which often require, so they talk about the shall issue and licensing, which often require applicants to undergo a criminal background check and are now designed to ensure only those bearing arms in the jurisdiction are in fact law-abiding citizens. They're going to bootstrap that up any way they can. They're going to use that phrase from Heller and Bruen, as they've already said 14 times. They're going to use that in order to bootstrap up whatever they can in order to, justify their ruling here. That's what they're going to do. See the writing on the wall, and I believe that they're going to paint themselves into a corner, and I don't think they're going to like the corner they get painted into if our side calls them out. And we need to call them out forcefully and loudly and directly for what they're doing. So on to this, to the contrary, Justice Scalia's majority opinion in Heller twice described prohibitions on possession of firearms by felons as both long-standing and presumptively lawful. Yeah. Let's not forget that in the first 20 seconds of the government's case in chief in Atkinson, the judges rebuked that. So, well, let's roll the tape.
Good morning, Your Honors, and may it please the Court. Kevin Soder from the Department of Justice for the government. I think it might be helpful to briefly take a step back. We're talking about a long-standing and critical piece of federal gun safety legislation under which individuals convicted of felonies are generally prohibited from possessing firearms.
It's not long-standing.
Well, the Supreme Court has referred to it as long-standing and has called out...
In dicta that is unexplained.
So I think
it's not long-standing by historical tradition. It's recent.
Don't take my word for it. Take the judges. They were not buying into this line of bullshit. No ifs, ands, or buts about it. They just were not. So, the Second Amendment was a pre-existing right. The court saw particular relevance in English history dating from the late 1600s, along with American colonial views leading up to the founding. That's going to be their justification, for bringing in pre-colonial law. England's Restoration and Glorious Revolution. Yeah, saw that one coming. We begin with the late 17th century when the English government repeatedly disarmed individuals whose conduct indicated a disrespect for the sovereign and its dictates. Also, the advent of the English Bill of Rights during this period confirmed Parliament's authority to delineate which members of the community could have arms by law. All animals are created equal, but some animals are more equal than others. This is the foundation for a very dangerous concept that just forget about whether or not somebody is a violent felon, a murderer, or rapist. They have forfeited certain rights within the confines of society. Now, they're going to go down a road. They're going to go down, just like you've seen Democrats in Congress trying to paint everybody that disagrees with them as a subversive, a terrorist, or any of that stuff. This is the path that this court is now going on. In short, the historical record suggests nonconformists, generous choice of words, as a group were disarmed because their religious status was viewed as a proxy for disobedience to the crown's sovereign authority and disrespect for the law, placing them outside the civic community of law-abiding citizens. So if you're nonconformist, if you disagree with the government, if you engage in civil disobedience, by this statute, Rosa Parks is not entitled to the Second Amendment. This is laying nonconformists. How about people who don't want to get COVID vaccines? How far are you willing to take this? Because this is an extreme line of thinking as to how they don't apply the term the people in any other right in this manner. Not the first. You don't lose your freedom of speech. You don't lose your freedom of religion. You don't, lose your freedom of the press, to petition government. None of that stuff in the First Amendment. You don't lose your Fourth Amendment rights. They don't get to question you or search your house or toss your vehicle just because you're a nonconformist. They do. Fifth Amendment, you don't lose your right to counsel. You don't lose your right to remain silent because you're a nonconformist, because you disagree with the crown or the government in this case, man. Historical understanding that the legislature parliament had the power and discretion to determine who is sufficiently loyal and law-abiding to exercise the right to bear arms. This just keeps getting better and better. You want to talk about true danger? This is a very dangerous precedent if this decision is allowed to stand as is. And it should be called out for what it is. And in 1689, Parliament enacted a status-based restriction forbidding Catholics who refused to take an oath renouncing their faith from owning firearms except as necessary for self-defense. So the very reason, one of the large reasons that the Puritans left England and jumped on the Mayflower was because of religious freedom. And here you're going to cite English law forbidding Catholics from owning firearms or being able to exercise what is now the Second Amendment. Sounds like Ireland. I mean, you wonder? Their perceived disrespect for disobedience to the Crown and English law that is manifest in the statute's oath requirement when individuals swore that they rejected the tenets of Catholicism and their right to own weapons was restored. Loyalty oaths? Really? So if you don't swear a loyalty oath to the Democratic Party, you don't get to have the Second Amendment? I mean, this decision up to this thing is only useful as birdcage lining or toilet paper. And it shows how much farther we have to go in the courts. And this line of thinking, that they are trying to bootstrap up and keep whatever governmental authority that they can because they see it slipping away. I won't say I'm at a loss for words, but I'm really shocked by how this is going. They would go this far. The disarmament of Catholics in 1689 thus provides another example of the seizure of weapons from individuals whose status demonstrated not a proclivity for violence, but rather a disregard for the legal binding decrees of the sovereign. Like vaccines. You defy the sovereign and peaceful protesters. They don't have, the riots we saw from 2 summers ago, they were mostly peaceful. That's, wow. The earliest firearm regulation in colonial America prohibited Native Americans, black people, and indentured servants from owning firearms. Wow. So you want to go back to that and say that because once upon a time we prohibited blacks, we prohibited Indians, we prohibited others from owning guns, that is a long-standing and justifiable, no matter how wrong it was. But here's the apology. The status-based regulations of this period are repugnant, not to mention unconstitutional. Then how in the fuck do you even cite them? And we categorically reject the notion that distinctions based on race, class, or religion correlate with disrespect for the law or dangerousness. We cite these statutes only to demonstrate legislatures had the power and discretion to use status as a basis for disarmament and to show that the status-based bans did not historically distinguish between groups violent and nonviolent members of disarmed groups. That's why we have a 13th, 14th, and 15th Amendment, because states and governments, local governments, were not willing to abide by the outcomes of the Civil War and whatever laws the Congress was passing down. But you think that, so we once had slavery, and you would then use that as a justification for indentured servitude or debtor's prison or something of the like today? Oh, it was repugnant back in the day, but since we did it once, we can do it in a different form today. You guys have gone right past full retard and pole vaulted to potato. During the late 1630s, for example, an outspoken preacher in Boston named Atkinson challenged the Massachusetts Bay government's authority over spiritual matters and instead advocated personal relations with the divine. The colonial government also disarmed at least 58 of Hutchinson's supporters, not because those supporters had demonstrated a propensity for violence, but to embarrass the offenders, as they were forced to personally deliver their arms to the authorities in an act of public submission. That's probably the most honest thing you've said in this decision to date. That you sit there and want people who will not kneel down, who will not kiss the ring, who will not bow down, to be publicly humiliated and forced in front of God and country to show their rightful submission to the state. F you. Likewise, Catholics in the American colonies, as in Britain, were subject to disarmament without demonstrating a proclivity for violence. It is telling that notwithstanding Maryland's genesis as a haven for the persecuted, that's why people originally came here, was all that. And now you're using that as a justification. I don't know. You guys are more backwoods than any hillbillies in Appalachia I've ever run into. Again, we cite the repugnant status-based regulations of an earlier period, disarming individuals on the basis of political affiliation or non-affiliation, merely to demonstrate the nation's tradition of imposing categorical status bans on firearms possession. You can try to apologize and put lipstick on this pig, but it's still a pig. And you're using something that is repugnant, your own words, to almost everybody in this country, and you're using that as a justification for 21st century law. That's what you're trying to do. You're the ones that are repugnant, no matter what. You absolutely are. Pennsylvania likewise disarmed nonviolent individuals who are unwilling to abide by the newly sovereign state's legal norms. The legislature enacted a statute in 1777 requiring all white male inhabitants above the age of 18 to swear to be faithful and bear true allegiance to the Commonwealth of Pennsylvania as a free and independent state. Yep, loyalty oaths. And failure to swear upon that was just enough to say you couldn't have the Second Amendment protect you. Instead, the Pennsylvania legislature forbade Quakers, here again based on religion, and other religious minorities from keeping arms because their refusal to swear allegiance demonstrated that they would not submit to communal judgments embodied in the law when it conflicted with personal conviction. For allegiance to their religious scruples over the new government. The act, in other words, was an effort by Pennsylvania's Constitutionalist Party to restrictively define citizenship that eventually became the people, to those capable of displaying the requisite virtue. Virtue. You mean like the virtue signaling the left does on Twitter and on social media and all that? That if you don't do it, you don't wear the right ribbons on your lapel, or think the right thoughts. Man, this thing just keeps they just keep digging this hole deeper and deeper. Exercising its broad authority to disarm individuals who disrespect the rule of law, Virginia's General Assembly also passed a loyalty oath statute in 1777. Boy, are they cherry-picking history in order to bootstrap up this law-abiding persons thing and the government's ability to So here, additionally, legislators in the American colonies, United States, authorized the seizure of firearms from individuals who committed nonviolent misdemeanor hunting offenses. In 1652, the New Netherlands passed an ordinance that forbid firing within the jurisdiction of the city of New Amsterdam or about the fort with any guns at partridges or other game that may by chance fly within the city, on pain of forfeiting the gun. North Carolina law prohibited non-residents from hunting deer in the King's West and stated that any violator shall forfeit his gun to the authorities. Yeah, these are criminal penalties for criminal statutes. Not that they lost their entire right to own a firearm. They are really reaching. We appreciate that these laws involve the isolated disarmament of firearm involved offense, not a ban on possession, as in other laws we discuss above. Nonetheless, they support the notion that the legislature's power to strip citizens of their arms was not limited. Yeah, they had the right to levy taxes. You guys are reaching to bootstrap up whatever you can. As these centuries of hunting statutes show, legislatures repeatedly exercise their authority to decide when nonviolent offenses were sufficiently grave to justify limiting violators. They didn't limit their ability to keep and bear arms. They just confiscated the gun in question for the act they were charged with. They didn't take all their guns. They didn't say you can't own anymore. Deference to state legislatures not only accords with long-standing national tradition, but also respects state legislators' unique ability to channel local concerns and values into criminal law. In addition to preserving federalism and the separation of powers, upholding legislative determinations of when crimes are sufficiently serious to warrant disarmament, avoids forcing judges to make difficult empirical judgments about the cost and benefits of firearms restrictions, especially given their lack of experience in the field. Bruen citing McDonald. All right, I'm calling bullshit. I'm throwing the flag on this one. These guys have completely misconstrued and misquoted Bruen. You know what? Let's jump over to Bruen and look at that. So here's the section they're talking about. Historical analysis can sometimes be difficult and nuanced, but reliance on history to inform the meaning of constitutional text is more legitimate and more administratable than asking judges to make difficult empirical judgments about the costs and benefits of firearms restrictions, especially given their lack of expertise in the field. McDonald. Federal courts tasked with making difficult empirical judgments regarding firearm regulations under the banner of intermediate scrutiny often defer to determinations of legislatures. While the judicial deference to legislative interest balancing is understandable and elsewhere appropriate, it is not deference that the Constitution demands here. They forgot that part. It's not deference that the Constitution demands here. The Second Amendment is the very product of an interest balancing approach by the people, and it surely elevates above all other interests the right of law-abiding, responsible citizens to use arms for self-defense. They're going to try to throw that law-abiding stuff back in our face, but it is clear that they completely butchered and cherry-picked parts of this section of the Bruen decision to buttress and justify what they're attempting to do in their decision here. Just mind-boggling. What else we got as we get through here? Our review of the historical record convinces us otherwise. Nonviolent individuals were repeatedly disarmed between the 17th and 19th centuries because legislatures determined that those individuals lacked respect for the rule of law and thus fell outside the community of law-abiding citizens. That long-standing tradition refutes Range's constructive account of Anglo-American history as prohibiting the government from disarming nonviolent individuals. Amici offer a few other statutes that purport to improve legislatures' inability to disarm nonviolent offenders, but these laws confirm our view. They were going to make their ruling come hell or high water no matter what. They were going to sit there and they came to this conclusion and that's it. what did they say here? I just saw. We believe the Supreme Court's repeated characterization of the Second Amendment's right as belonging to law-abiding citizens supports our conclusion that individuals convicted of felony equivalent crimes. But you said the non-law-abiding could be blacks, Native Americans, Catholics, and people of that sort. That's how you get to this decision. That's how you bootstrap this up. Focusing on acquiring the meaning of the people also comports with the Lockean principles of animated founding era disarmaments of individuals whose unwillingness to abide by communal norms place them outside political society. By that, at one point in time, the Gay Pride Parade will put them outside the norms of political society. Is that what you're telling me? You guys just... We have conducted a historical review that is required by Bruen, and we conclude that Range, by illicitly taking welfare money through fraudulent misrepresentation of his income, has demonstrated a rejection of the interests of the state and of the community. He has committed an offense evincing disrespect for the rule of law. As such, his disarmament under 18 U.S.C. 922 G1 is consistent with the nation's history and tradition of firearms regulation. Wow. So this is what we're going to see going forward. This is what's going to happen. They are going to use law-abiding. They're going to use long-standing. They're going to bootstrap up these morsels of New York to get what they want and get them to where they think they need to be to preserve the state, because you're not getting down on bended knee. Far cry from what we heard in Atkinson. I'm hoping that the judges simply issue an opinion in Atkinson. If they see this, I don't know if they will think the government's going to get another bite at it. But most of this ruling runs contrary to everything we heard in the arguments. I mean, the one judge said, don't sign us up for this blanket, reading of. So with that, we get this opinion. We get an opinion going the other way in the Seventh Circuit on how to define all this stuff. And you have a conflict within the lower court of appeals, which tees it up for the Supreme Court, which we may need them to define long-standing and law-abiding and the like. Or this could get appealed up to them and they could turn this one away and accept the Seventh Circuit or vice versa. But they have a conflict within the courts if the Seventh Circuit goes our way. So with that, go back and read this. This is a dangerous precedent if it's allowed to stand as is and if it's adopted by other courts. It truly is. That religion, that they are saying that the basis of religion, the basis of your race, they can all be used, and they want to expand, that the government has a free hand. If they say DUIs are laws that now, well, you're not law-abiding because you had a DUI or anything like that. This is a very dangerous decision. So guys, it's always good to have you back. Please hit that like button. Share this in your social media, Facebook, whatever. Hit the subscribe button. And we're going to be getting around to do more of these. We've got a few other topics coming up here. Going to try to knock some out. So with that, as always, guys, frag out.